What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly case update. I got a bunch of cases for you this week, 8 total cases, so let's get right to them. First one is Melton versus Melton. It's a dissolution of marriage case, has to do with temporary support. And these first two cases have something in common. They both involve a lack of a record on appeal, a lack of a transcript. So in this Melton case, it was a temporary support case. And so the issues of imputing income to the wife and her entitlement to credits for health insurance payments, those were affirmed because there was a lack of a transcript. But what was apparent from the face of the order was that the trial court ordered the husband to pay more in temporary support than it found his actual net income was. So somehow, I guess it was the trial court was saying you got to get money from somewhere else because it ordered him to pay additional child support in excess of the amounts that he was supposed to pay from his net income in temporary alimony. So he already depleted his temporary alimony, his net income in temporary alimony, but he still had to pay child support. And where would that come from? So that was apparent on the face of the order, so that was reversed. Next case is Thompson versus Vilches, a third DCA case. It's a domestic violence injunction. This is one where it's super important to have a transcript. I don't know how they didn't have a transcript here, but basically the record didn't support vacating the domestic violence injunction that was entered against the mother. What happened here was the mother allegedly committed battery against the father in front of the child. So the father filed a domestic violence petition on behalf of the child. And what happened, what's important is that the mother's conviction, she was charged criminally, but her conviction was essentially thrown out based on stand your ground. And in other words, it was self-defense. She was defending herself against the father. And so notwithstanding that, in the actual domestic violence case, the court awarded the husband, the father, 100% time sharing because it was only based on the domestic violence proceedings. So the mother was trying to get out of that essentially by saying, look, I wasn't the aggressor, I was defending myself. But the court said that because there was insufficient evidence in the record on appeal, mother was out of luck just as it regards this appeal. She apparently didn't prove her change in circumstances at the appellate level, or at least show a sufficient record of it. So thankfully this is without prejudice to the mother filing an appropriate motion in the trial court, in the family court regarding time sharing. But still, make sure you have a transcript and a court reporter, and make sure you preserve your record so you can set forth your arguments on appeal. Next case is Rosa versus Heredia. This is out of the 5th DCA, another domestic violence case. Well, basically, this was domestic violence allegations a year prior. So I know that the statute says that domestic violence includes any battery and it's a whole litany of things. But it does have to be, pursuant to the case law, it has to be temporal in nature. It has to be, it can't be too long ago. So there were allegations, what they called vague allegations of domestic violence in another state from a year ago. And that was not sufficient, particularly where the evidence in this case was that the person claiming the injunction was, I think, the ex-girlfriend. And she was saying, she was apparently contacting the ex-boyfriend repeatedly, and the ex-boyfriend was the one that was saying, stop, I don't want any contact with you. And also the mom admitted that the ex-boyfriend really had no idea where she even lived. So I think it was sort of the petitioner may have been the one that was really bringing this on herself. Next case is Allen versus West. This is out of the 3rd DCA. This is an issue of very, very important issue as well, trying issues by consent. So this wasn't in the pleadings, but apparently a change in parental responsibility and time sharing came up at the hearing, and it was presented in the pretrial catalogs, or joint pretrial statement, and nobody objected to it, and then it was tried by consent. Oof, big no-no. You got to make sure you object to something like this. If somebody tries to insert issues into the case at the last minute at trial in the pretrial catalog or something like that, just object to it so you can preserve your right to appeal and that they're not tried by consent. So that's what happened in this case. They said, well, the issue of changing parental responsibility was tried by consent, so too bad. Next case is Maradona versus Villafañe. This is a sort of, it's not exactly a family law case. It was a case involved, it was a divorce case where the parties signed an MSA. And then after that, there was litigation years later, basically about fraud, trying to say that the wife failed to disclose a variety of real properties that she actually owned. And the former husband filed this in looks like, I think, Circuit Civil Court for basically a common law case of fraud. So there's two issues in this case. The first one was that basically the fraud didn't stick because they waived all their rights in the marital settlement agreement, and also he could have just researched the properties online. They were all available to him before he signed the marital settlement agreement. He could have just looked at the property records because they were all publicly available. So he failed to do that. So his fraud case failed. The other issue, though, is that he was held in indirect criminal contempt for a violation of a discovery order, allegedly. And so the problem here was that the trial court did not follow the procedures for indirect criminal contempt. Unlike civil contempt is just, you can have a family court judge, you can have a civil court judge, and there's not extra procedural requirements. If it's a criminal contempt, remember, criminal contempt is something for vindicating the court's authority. It's not to compel compliance. Compelling compliance is what civil contempt is. If the court wants to impose an order to make one of the parties do something, that's civil contempt. It's criminal contempt when it's more like punishment. And so apparently in this case, the trial court treated this as a criminal contempt, but they failed to provide the order to show cause. They failed to provide the rights to an attorney, and there's a whole section of procedures that you have to follow under Rule 3.840. So the trial court failed to abide by that, so that got reversed on appeal. And that was substantial because I think it was like an $84,000 attorney's fees award that got reversed. Next case is Golubtsova versus Budaev. This is a lis pendens case. I know in a lot of our divorce cases we like to slap lis pendens on real property in a divorce case, but this was actually, I think this was post-judgment divorce, where the former wife was saying that the former husband failed to provide rent they had a bunch of real properties together, I guess, and he failed to give her share of the rent. So she filed a civil case against him, and she slapped lis pendens on all the properties. Well, the husband filed a motion to dissolve the lis pendens, which was proper because she could not show a fair nexus. That's the standard. You have to show a fair nexus between the complaint that you filed and the property. So you have to have either an ownership interest in the property or some sort of fair nexus where the results of the lawsuit could potentially give you some sort of right to title, right to a claim or interest in the property. So in this case, she was really just seeking monetary damages, not ownership of the property. She said she was doing a constructive trust, which I think a lot of times people will claim that, but that wasn't good enough because in the nature of her actual claims was monetary damages. So the lis pendens, bye-bye. Next case is the Department of Children and Families versus KR. So this is a super sad case, in my opinion, because this poor kid, his mom died, and his legal father, who was married to his mom apparently at the time he was born, not his biological father, but this was his legal father. Essentially, the legal father wants nothing to do with him. So this kid's without any parents, but one of the parents, the actual biological father, does want to be, in his life and have rights to him. So the biological father at the hearing on the shelter, because apparently I think the sister of the mom's husband or somebody like that wanted to take care of the child and was sheltering the child temporarily. So she wanted to adopt him. And so at a hearing in front of the dependency court for the first time without notice or anything like that, the dependency court heard allegations that the biological father was the actual biological father. He had a DNA test results showing he was 99% chance he's the dad. And so the dependency court essentially granted parental rights to the biological father. And the reason this got reversed was that it was no due process. So DCF was entitled to due process on these allegations of paternity, right to cross-examine, right to, take discovery and things like that. So that got reversed. So, but still, this poor kid, he's caught in the middle. Next and last case is Hart versus Moore, ex rel Hart. This is another injunction case. And this is one where the father actually provided evidence of a change in circumstance. So he got a domestic violence injunction against him basically filed by his child, but the mom files the petition against the father on behalf of the child. The father moves to dissolve the injunction later on based on change in circumstances, and the court actually erred in denying that motion to dissolve the injunction because he proved that there was a substantial change in circumstances, and importantly, the child's representative, which was the mom, basically testified that she left the decision whether to have time sharing up to the child. So if the mom left the decision up to the child whether to have time sharing with the father, then that shows a lot about whether there's been changed circumstances to allow the father to have the contact with the child and to lift the injunction. So the denial of the motion to dissolve the injunction was reversed. All right, guys. Sorry, I know that was a mouthful this week, but I hope everybody enjoyed it, and I'll see you guys next week. Take care.